you. Merci. Christopher Dunn versus Her Majesty the Queen. Solomon Friedman for the appellant, John S. McInnes, and Roger Shallow for the respondent. Mr. Friedman.
Morning, Chief Justice, Justices. Before I begin on the substantive argument, obviously this is a case that revolves around the interpretation of defined terms in the criminal code, and by simply perusing the two facta, the court clearly sees that there's some possibility for what I would call ordinary meaning versus defined meaning. So I want to start out to clarify the terms that I use as defined terms and proceed from there. And I think my friend and I are of one mind in terms of using a standard nomenclature here to keep matters relatively straightforward. We talk about firearms and weapons in the defined sense. The appellant also raises the issue of firearms in the colloquial sense. That is, a firearm, and I'll avoid the use of gun. Crown Counsel uses that to encompass all the objects at issue here, but a firearm being a standard gunpowder activated firearm, like what would may colloquially be known as a firearm or a gun. With respect to air guns, we have created three somewhat artificial categories, that is the low, medium, and high-powered air guns. Those aren't categories created by the criminal code. The code only distinguishes between air guns above a certain velocity and air guns below a certain velocity. The issue, moreover, and the court saw it, of the pig's eye test is also not a creature of statute. It's simply a way of addressing the issue of whether or not this object can cause serious bodily injury or death. And those that fall below that range are described as low-powered air guns. Objects that can cause serious bodily injury or death, and the evidence in this case is before the court in terms of the testimony of the expert and the pig's eye test, those are what we call medium power air guns until they reach that threshold of velocity, which is set out in Section 86 of the code, which then would trigger the licensing provisions, licensing, formally registration provisions of the code. In my respectful submission, the chief issue that the court needs to grapple with, and the Crown's primary contention in this case, is this question of, would Parliament have used a term like firearm in the definition section of weapons specifically in its colloquial sense? And that's a difficulty for the appellant, in that in the appellant's submission, and based on a reading of Filoka, the solution to this definitional loop problem is that firearm carries both a legal meaning, but it also carries an ordinary meaning. And that this court's decision in Filoka was based on firearm in its colloquial sense. And the words of Justice Corey ring true when one considers a firearm in its colloquial sense. The Crown contends that this is a defined term, and a defined term has an exhaustive meaning. The code tells us what this term means, and that's a meaning which applies from the beginning of the code to the very end. And in my submission, this question must be asked squarely of the respondent as it is of the appellant. Because, of course, the respondent's solution is to do the very same thing with the term weapon. And the respondent would say that when the code speaks of a weapon in the firearms definition, it doesn't really mean weapon, despite the fact that weapon is a defined term in the criminal code. Now, it's not a complete answer to say that my friend, I'm no better than my friend, or vice versa. But those are issues that the court needs to address, is going to need to answer that question, whether it's with respect to firearm or whether it's with respect to weapon. The appellant's position, obviously, is that when we're dealing with the issue of firearm, within the weapons definition, it can have a distinct meaning from the defined meaning in Section 2 of firearm. In order to escape this definitional loop, one of those two things has to be true. The appellant's position is based on a reading of Filoka. The respondent characterizes the appellant's position as really placing too much weight on rhetorical flourishes, that when Justice Corey was alerting the court to the dangers of firearms, and he was talking about the menace that firearms pose and their potential for lethality, that he was doing so really rhetorically, and if that doesn't apply with equal measure to air guns, that no more should be read into that. And I'd ask the court to take the Appellant's Book of Authorities, tab 4, to read the words of Justice Corey in context. And I refer the court to paragraph 21. And that's at page 9 of the decision. And of course, the court in Filoka was grappling with a different question, although the same two related definitions, and that was whether or not the criminal code, when it included firearm in the definition of weapon, did so without an eye to the offensive or intended use of that object, that firearm, or whether or not a firearm was always a weapon within the meaning of the code. Now, the respondent points to the fact that, of course, Justice Corey is referring to firearm in its defined sense, as defined in Section 84. That's where it was found. But we need to read further in my respectful submission. And at paragraph 21, Justice Corey tells us, in my view, a firearm must come within the definition of a weapon. And it's curious, though, why the court found it necessary to read in to the meaning of a firearm. If it's a straightforward matter of statutory interpretation, we have one defined term within another defined term. But we're given the reasoning, which in my submission gives us some insight into Parliament's purpose here and a way to discern the harmonious reading of the Act. And Justice Corey tells us a firearm is expressly designed to kill or wound. It operates with deadly efficiency in carrying out the object of its design. It follows that such a deadly weapon can, of course, be used for purposes of threatening and intimidating. And Justice Corey describes those purposes, what it means, why this is a tool which is effective for threatening or intimidating. And he continues at the end of that paragraph, a firearm is quite different from an object such as a carving knife or an ice pick, which would normally be used for legitimate purposes. A firearm, however, is always a weapon. No matter what the intention may be of the person carrying a gun, the firearm itself presents the ultimate threat of death to those in its presence. And of course, that distinguishes a firearm from any other object, because for every other object in our law, before it meets that threshold of weapon, we need to determine what its intended use, what its design was, whether the user of it intended it for an offensive purpose, except for firearms. And there's a reason for that. And the reason is because firearms are a special category of object. They're expressly designed to kill or wound. And in Lebrec, in the summary conviction appeal court, and this is at tab 3 of the appellant's book of authorities, paragraph 7, Justice Rutherford reached the same conclusion that I'm asking the court to reach today. And that is to solve the definitional loop by looking at the intrinsic difference between quote-unquote real firearms and an air gun such as the object which is at issue in the present case. And like Justice Rutherford, I'd ask the court to, by simply reading the plain meaning of filoca, not to read it as rhetorical flourish, but to reach that conclusion that we're talking about, as Justice Rutherford calls it, a conventional powder-fired bullet-shooting gun.
How does that square with what Justice Corey said in paragraph 24?
Now, I think my response to that was that we need to separate out the plain statutory interpretation, that is to say, there's definition of weapon here. It includes firearm. But Justice Corey tells us why it includes firearm. Now, I don't think it's him reading, we're not trying to read the minds, if we put it that way, of the drafters, but we have a definition here. We have something unique about this object, and the court tells us there's something unique about this particular class of object, and that class of object, in my submission, is not the object at issue in this case. And I think that Justice Corey is also alluding to, in paragraph 24, he doesn't answer the definitional loop problem. In fact, the definitional loop is never raised here. This is a new opportunity for us to take that question, that is a definitional loop, and read filoca in light of that problem. It wasn't raised. Because otherwise we get caught in the very same loop. And my submission would be that filoca doesn't address that loop. And this case is this court's opportunity to do that and to determine whether or not a filoca should be narrowed in light of whatever the response is to that definitional loop. And obviously the appellant urges that the colloquial meaning of firearm be adopted into the weapons definition.
Can I just ask you what the implications of that would be? I want to understand how your argument would work, for example, with respect to the high-powered air guns. Looking at Section 85 and 86, use of a firearm in commission of an offense or careless use of a weapon and so on, would it be your position then that a high-powered air gun would be excluded because it's not fired by gunpowder? When do we decide? I take your submission that you have to look at the ordinary meaning of firearm. But are you saying that you wouldn't look at the ordinary meaning of firearm for the purposes of Section 85 and 86?
Well, thank you, Madam Justice. That's an interesting question. We look at Section 86, or if we begin with Section 84, and those are those exceptions to the licensing scheme. The Code begins by telling us in Section 84, sub 3, that the following weapons are deemed not to be firearms. Now, perhaps here the respondent would urge that weapon, in that sense, also only means object. But the code tells us that we're dealing with a category of objects that are otherwise weapons. Now, it may be, Madam Justice, that the high-powered air gun category would itself meet the weapons definition. Is it intended to be used to wound or maim, etc.?
So it would be on a case-by-case basis? Is that what you're saying, that Section 85 or 86 would apply to high-powered air guns, depending on the intention of the person possessing it?
Section 84 already tells us that this is the problem that the respondent refers to as the flickering light bulb, that the status of an object is going to change depending on the intention of the person using it. And my response to that is that the code already does that. The code already does that at Section 84.3. And I draw the Court's attention to 84.3, paragraph C, where the code says that in the list of weapons that are deemed not to be firearms, included there is any shooting device that is designed exclusively for the slaughtering of domestic animals, etc. So we're talking about a device used to slaughter or tranquilize or discharge projectiles with lines attached to them, and this is sub 2, intended by the person in possession of it to be used exclusively for the purpose for which it is designed. So my response to the respondent's contention that we have a item that jumps categories based on the intention of the person using it, that's, with the greatest of respect, not the Court's issue, that's Parliament's issue. Parliament has already defined categories of objects based on the intention of the person using them. And of course, it did this, I say way back when we talk about a weapon. The very definition itself of a weapon, leaving aside the firearms category, is a category of objects whose legal definition depends on a number of factors and has to be addressed on a case-by-case basis.
So I still want to understand what your position is when it comes to the high-powered air guns for the purposes of Section 85, 86, 87, 88, and so on. Are they included or not? Or are they excluded because they're not, powered by gunpowder?
It's quite possible that we can read 84 as including automatically high-powered air guns in Sections 86, etc., all of the non-licensing provisions, by simple exclusion, by the fact that the code itself is distinguishing between medium and high-powered firearms. But it shouldn't trouble the Court that we have a distinction like that. That's the distinction that the code makes itself. It's not the effect of a decision in this case.
Just spend another minute on the question of sub 2, intended by the person in possession to be used. How are we to look at that definitionally? The gun in quest, the air gun, has a warning on its side. Not a toy. Misuse can cause fatal injury before using, read, whatever. So are we to decide whether something is an air gun or whether something is a firearm depending on the use to which the person is putting it, or can it be seen objectively when there is a possibility, according to the manufacturers, of fatal consequences? Okay. In other words, this is looping into Parliament's intention, which I'm sure at some point you're going to get to.
I will. I would begin by asking the Court not to place too much reliance on the label, the description that a manufacturer gives an object in terms of its legal consequences. We can address the issue of whether or not this is a weapon. It can be done both either objectively or subjectively. We have objects that are designed to wound or maim a person. The example would be like a pair of brass knuckles. And you have objects that are otherwise neutral, that are not necessarily weapons until the individual demonstrates some intention to use them in an offensive manner. And it's my submission that that's the category that air guns fall squarely into. Then it becomes an evidentiary matter. And in this case, for example, if we look at the trial record, the court considers what was the use, what was the effect of this firearm in terms of the evidence of both the surveillance officers and the other individual involved in this altercation, this interaction rather. But that's how that object is designed. Sometimes it will be apparent, depending on the nature of the object, but a warning that an object isn't a toy doesn't mean that it was designed to intimidate or wound.
What is the purpose for which this particular item was designed, in your view?
In my view,
when it has the possibility of fatality by the manufacturer on the side.
It's a recreational object, like many others, that can cause bodily injury. It's a baseball bat. It happens to be barreled, but a baseball bat's a sporting object that can cause horrific injury. And I would also, in that way, deal with the issue that the respondent marshals civil cases showing the potential of lethality and injury that can result. That's not the question. That's conceded on this record with respect to the pig's eye test. There's no question of what it can do.
But for many people, guns there are millions of thousands of guns anyway in this country, and people using them for recreational purposes, powder. So the distinction seems to break down. Most of the people who have registered guns, all of them, we presume, are not going to use them to kill people. They're going to use them for hunting or maybe agricultural purposes, or I don't know, but certainly not for killing people. That's not why they are sold and licensed. So this sharp distinction seems to break down, doesn't it?
And in my submission, that was the issue in Filoka. That's where that distinction was put to rest on the basis of statutory interpretation.
Yeah, I know, and there are passages where Justice Corey speaks of, first of all, the capacity for death or injury in paragraph 21. Then last sentence he talks about death, but there's certain rhetoric there. You're asking us to put a statutory meaning on those things. One can argue that guns are designed to inflict death if necessary. They're also designed for target practice. They're designed for recreation and agriculture and self-protection and lots of other things. So we have to take that, don't you think, rhetoric in paragraph 21 with that in mind?
I do. I'd also note, and this isn't the issue before the court, that the definition of weapon doesn't talk about its capacity or its design simply for causing death or injury, but it talks about it, whether it was used, designed to be used, or intended for use in causing death or injury to any person. That there may be some firearms that are designed exclusively for that purpose. There may be others, perhaps one could say that if it's designed for causing death or injury to an animal in the hunting context, then it wouldn't otherwise satisfy that criteria. Now, that question was answered in Filoka with finality, and it's not the appellant's intention to reopen that. But the simple capacity of a given object to cause bodily injury or death, in my respectful submission, doesn't automatically go to what it was designed to do. And we do this on a case-by-case basis anyways. That's something that goes on in the criminal courts all the time in determining we have a given object. Does it fall within the weapon definition? And the judge will look at a wide range of factors. We'll look at what was it designed to do. Some objects it will be apparent on its face. How was it used? How was it intended to be used? And we'll look at the words of the individuals involved. That's going to be the work of the trial court in any event when we're dealing with a purported, quote-unquote, weapon. I want to turn directly to the issue of parliamentary intent. And it's in this area where the appellant raises the statutory and legislative distinction between air guns, our medium-powered air guns, the object at issue in this case, and either high-powered firearms, high-powered air guns, which are subject to the licensing and formerly the registration scheme and all the attendant provisions of the code. There's a distinction there, and it's a legislative distinction. I speak of an individual who is put on notice that he's entering into a zone of highly regulated conduct. And that's what happens in the ordinary firearm sphere. In order to obtain a firearm legally in Canada, one takes the Canadian firearm safety course, one applies for licensing, and depending on the nature of the firearm, one registers that firearm. Notably as well, the criminal code has imported the Firearms Act regulations concerning the storage, transportation, and use of firearms. And that's in Section 86, subsection 2, that a violation of those regulations is a criminal code offense. So if we pause to ponder for a moment legislative intent, we have a scenario where an individual walks into a Canadian Tire. There's no legislative requirement that he take a safety course, that he or she pass a background check, get a license, purchases one of these objects, walks out of the store with the object in his or her shopping bag. Now, we stop right there. We don't even need to get to careless storage. If we read FILOCA, if FILOCA means what it says, then that individual is carrying a concealed weapon. And the moment the cashier puts that object in his or her shopping bag, FILOCA talks about exceptions to the concealed weapon provisions if you're complying with federal or provincial regulations, if it's a case that clearly identifies the shape of the object. But this individual has no such protection.
Well, maybe there could be a charter challenge brought if that was a circumstance and that was the charge and so on. I mean, this case has been sent back for a trial. Who knows what your client is going to raise on the trial. But I think what you're talking about there perhaps goes to moral blameworthiness and so on and so forth, and you got to have a guilty mind, and we don't send Section 7 arguments and so on. But that's not our concern, is it, today?
Well, the concern that that issue raises is that Parliament is presumed to act constitutionally and is presumed to enact laws that are constitutional. That doesn't mean that there's a charter challenge on that specific issue. And in terms of a guilty mind, the fact that it's unfair, we know ignorance of the law is not going to be a defense here. It's not going to be a defense for an individual.
I'm not talking about unfairness. I'm talking about the security of the person put at risk by virtue of a law that really, in a circumstance where the person is morally without blame. That's what I'm talking about. So, I mean, this hasn't been tested. It may be or it may not be that that will be a defense based on warnings on this, the packaging and so on. But I guess, again, I come back to, I don't think with respect that that is our issue today.
No, and I think we can actually take that one level further, and perhaps it'll exacerbate your concern, Mr. Justice, or maybe it'll attenuate it. And that's when we get into the safe storage field. There are rules for how one must store a firearm, and this is a tension between the appellant and the respondent in this case. The appellant would urge, saying, absent an object being defined within the criminal code definition of firearm, then the ordinary criminal negligence rules apply. And it will be much like any other object that has the potential for danger. If there's a criminal negligence standard met, well, then it'll meet it, but it doesn't have a careless storage standard. For a firearm, no harm, no foul isn't a defense. If one breaches the regulations, one commits an offense under Section 86, sub 2. But is it logical that Parliament would create a class of offenses where, with respect to firearms, it gives specific and detailed, or when I say real firearms, gives specific and detailed guidance about how to avoid criminal liability, if we put it that way, but creates that same offense with respect to our medium-powered air gun, but with no regulations governing conduct. That's in my respectful submission, that's not a fairness or a charter argument. That's a statutory interpretation argument.
If somebody had been injured, what would we be entitled to call this object?
It depends how somebody was injured, Madam Justice.
From a projectile from the object.
I think we need to go even further than that. Was it used carelessly? Was it used recklessly? Was it used with an offensive intention?
So tell me how I should be thinking about what it is if somebody is injured, leaving aside the mens rea, whether
it's a medium-powered air gun. It is what it is in that sense.
That's exactly what I'm asking you. So is it a firearm or is it a weapon?
If it's used to hold up a store...
If the effect of its use... I don't want to get the mens rea argument into it.
Fair enough. If the object itself is used to rob a store, then that object itself... And maybe we can step away... Maybe this is helpful to actually deal with in the abstract. If we step away for a moment from our air gun case, and we'll return to it to answer your question squarely. If one takes any object that's otherwise neutral in our law, we look at what was the intention of the user, what was the effect of its use. In other words, was it intended to intimidate or cause harm to a person? And was it so used? And instantly this object will transform from an otherwise neutral object, we can go back to our baseball bat, to an object that carries criminal liability under our law. If it was...
As what? A weapon?
As a weapon.
Okay.
Well, then... Oh, sorry.
No.
Well, it seems to me that this argument is the argument that the majority rejected, including in Falaka. I mean, I agreed with Chief Justice Lemaire that weapon says used, designed to be used, or intended for use, and Chief Justice Lemaire said, well, is it actually used? Was it designed, bracket, exclusively for use or intended for use, cause injury, death, or to threaten, etc.? And if you take that kind of definition of weapon, maybe your argument makes sense. But the problem is that the majority of this court in Falaka said no to that. So maybe you're trying to go back to the minority position. I think it has a lot of sense, but it's been overruled.
I thought you would, Chief Justice. And the respondent characterizes it as putting a gloss on Falaka. And I would ask the court to do more than that, but not overturn Falaka, but to address the statutory interpretation question in Falaka from its underpinnings. Why was it so obvious to the majority that a firearm doesn't need to meet the ordinary definition of weapon? And that was a response given based on certain characteristics, which in my submission, this object does not share and cannot then be imported wholesale into Falaka, specifically when the court needs to grapple with the definitional loop.
That's pretty awkward, though, given the reference to Formosa in paragraph 24, isn't it?
It is awkward, but that issue wasn't before the court in my submission. That wasn't being directly argued here. In other words, and more importantly, the implications had not been extended to other objects like our medium-powered air gun with questionable legal status. And I understand very much that concern, but the question is, what was before the court in Falaka, and what, without maybe divining some statutory status to the words of Justice Corey, and that's not what the appellant is urging here, but it's to determine why was it so obvious that firearm should be included in that category. This court hasn't addressed squarely the issue of the definitional loop particularly here with respect to our medium-powered air guns.
It seems to me it gives rise to the expression "da." If you look at the definition of weapon, and then Parliament goes on and says, without restricting the generality of the foregoing, includes a firearm, why would that be necessary at all? It just makes no sense whatsoever to throw that in if you didn't mean to be hiving off a particular item and saying this will always be a weapon. Otherwise, as I say, it's a "da." Why would you do that, Parliament? What's the purpose? What's the sense of that?
And that's the holding, that's the majority in Falaka. And that was their answer. And they gave reasons why. That was their answer, right? I mean, with the greatest respect to the position of the Chief Justice and the former Chief Justice, in that case...
Right, I didn't mean "da."
I'm simply trying to stand up for the Chief Justice's honor here. But it appears to be... It appears to be, as you put it, Mr. Justice Moldaver, a straightforward statutory interpretation question. Okay? But it's interesting, though, that the dissent, the full-throated dissent in Falaka, speaks to this, what the appellant characterizes as a potential injustice, that there's an unfairness here. And my submission today is, if there wasn't an unfairness in Falaka, and we can't reopen that, I'm not asking the court to reopen that discussion, there's an unfairness here that flows from Falaka, and the court should confine its decision in Falaka accordingly. That's the sole intention of the appellant in raising Falaka. I think I was in the middle of answering your question, Justice Abella, and I want to return to it briefly to ensure that my meaning is clear. It's the appellant's position that if an object hasn't met the criminal code definition for firearm, and furthermore that definition has in and of itself as an element weapon, then its legal status has to be determined. It remains to be determined. And if we go to that definition of firearm for a moment, why does Parliament use the word weapon? There's a really great other word that they could have used, and that's object. It's a neutral term. It's not a defined term. In my submission, after reviewing the respondent's critique of my solution to the definitional loop, that problem remains. The awkwardness remains. The absurdity remains. That is to say, had Parliament wanted to use a neutral term, divorced from a legal defined meaning, it could have done so. So, why then does it use the word weapon? And the appellant's response to that may create awkwardness in the legislation, but it doesn't do so at the expense of logic any more than, and I know the respondent is careful to avoid using this word, but the respondent wants the court to read down the word weapon and to read in there another word, a neutral word. And on balance, does that do more violence to the statute than doing the very same thing with the word firearm in the weapon definition? And that's the appellant's contention when it comes to the definitional loop problem. I wanted to address, if I could, the issue of Section 244 and 244.1 of the Code. And those are the parallel provisions with respect to discharging either a firearm or an air gun with intent. And that intent is to wound, maim, or disfigure, alternatively to endanger the life of any person, or to prevent the arrest or detention of any person. And I asked the court to divine meaning from the fact that we have two parallel provisions. One criminalizes this conduct with respect to a, quote, firearm, and the very next one, passed in tandem, addresses the discharging of an air gun with exactly the same intent. The respondent contends that I'm asking the court to make too much of that. And in fact, this was a very wise legislative decision by Parliament because it gave prosecutors the discretion to lay a charge under 244 or 244.1. And the Court of Appeal, Justice Rosenberg, dealt with this issue, and he compared it to two offenses where there's overlap between the offenses, like theft, for example, and joyriding. And in my submission, that logic falls apart when we probe it a little deeper. If the respondent is correct, then we have two offenses with identical mens rea and actus reus. An air gun, specifically an air gun that is at issue in this provision, is always a firearm, says the respondent. So,
there are air guns that aren't. There are air guns that do not fit within that definition. So one argument could be that for those air guns that are not capable of causing death or serious bodily injury, they could still look like a real gun, and you could discharge it, and you might endanger someone's life by doing that, or you might be using it to try and help someone avoid arrest. There are some, they're not exactly, it seems to me, mirrored, but...
And my submission would be in that regard, we read the provision talks about discharging this air gun with intent to wound, maim, or disfigure, and it's with respect, it seems an odd sort of offense for Parliament to create, that is, to use an object which is incapable of producing the result that you intend, but that intention in and of itself produces a criminal consequence. And perhaps, Mr. Justice, I would agree if this was about preventing the arrest or detention of a person, right? That we can understand you discharge a firearm, a low-powered air gun, the person on the other end doesn't know, but the code is criminalizing the intent to wound, maim, or disfigure when plainly this object's incapable of so doing.
Or endanger life. I mean, we could get very theoretical about this, but if I had a gun that looked real and I fired it and you're standing on the edge of a cliff and you think, boy, I better jump, or I'm standing on a balcony and I'll take my chances. You know, I mean, I know it sounds bizarre, but...
No, we're beyond splitting hairs here.
We're talking about intent here.
And fair enough. My solution to these two provisions is to read them simply. Air guns are not always firearms. When they are, they're captured by 244. When they're not, and they really fall within the type of object that Parliament appears to be describing in 244.1, well, they're captured that way. And I also want to point out that the issue of using these two provisions for prosecutorial discretion is an odd route in my submission. If, for example, Parliament wanted to do that the simple way, and what we're dealing here, we're trying to determine the intention of Parliament. If Parliament wanted to do that, the simple thing would be to create a hybrid offense and to allow the prosecutor to elect in appropriate circumstances if there really was such substantial overlap between a air gun, and specifically an air gun that would appear to be at issue in 244.1, and a firearm. my final submission to the court is that the definitional loop problem, if it leaves this court with ambiguity in the meaning of the statute, then this court should resort to the rule of strict penal construction of statutes. And that's the reason why I emphasize the fact that the respondent's solution to the loop carries with it the same difficulty, the same logical difficulty, the same difficulty of internal coherence in the criminal code as the appellant's submission. Obviously, I lay out, and hopefully I've presented in some way, why I find my solution preferable. But if at the end of the day this court doesn't find one preferable over the other, then in my submission we're dealing with a case of ambiguity. And I want to address the respondents, what I think seems to be an implicit contention that the appellant's seeking to stretch that rule of ambiguity. And it's important that this court knows that's not the appellant's intention in any way. We're not seeking to expand ambiguity to being a substitute for the court performing its statutory interpretation function. The submission is, however, that even with all that, that is to say, even by looking at firearm and weapon side by side, looking at the implications, looking at the other provisions, if there remains ambiguity, then the court must interpret this legislation in a manner that prohibits the unfair or harsh consequence to the accused, because at its heart this is a criminal law provision. I don't know if the tie goes to the runner, but if there is truly an ambiguity here, then this statute, this penal statute, ought to be constructed strictly.
What would a strict construction look like?
The strict construction would address the definitional loop problem in my submission. And it would ask, which word are we going to read down? Weapon or firearm? If we read weapon down as object, then we're left with a circumstance where criminal liability attaches to the, quote, non-offensive, if we put it that way, use of these objects. If we read firearm in the weapons definition as referring to a conventional gunpowder-powered object, a colloquially a real gun, then criminal liability does not attach to the non-offensive use. So the concealed weapon, the careless storage provisions. And that's the strict construction should this court find that there is indeed an ambiguity here. Subject to any questions of the court, those are my submissions, and if there's a need for extra reply, I'd ask to reserve my time for that.
Thank you very much, Mr. Friedman. The court will rise for its morning recess. We're very grateful for your submissions, Mr. Friedman, but we will not, in the result, need to call on Mr. McInnes. The court is ready to deliver its judgment now. For the reasons of Justice Rosenberg in the Court of Appeal, we are all of the view that the appeal should be dismissed. Court stands adjourned.